Yes, Mr. Mshololo.
Okay, my lord, firstly, on a Tuesday when we adjourned, my lord, the state supplied to us the incomplete information, the incomplete statements of Colonel Genenda, my lord. We were told that they will be supplied later in the day, which was on Tuesday, on the 30th of April, my lord. And those pages, they never came, my lord. Out of the bundle that was supplied to us on the 30th of April, my lord, there was a bank records for accused number 5 from Absa Bank. I managed to secure a consultation in prison, my lord, even if it was not, legal visit was not allowed. However, the head of the prison allowed me to consult. I consulted on that document, which is Absa records, which was made available to me on the 30th. This morning, I received another bundle of documents from the state, of which I have not been able to read them. I can see also the email was sent last night at 2300 hours, of which I was not told not to sleep and wait for this email. Unfortunately, I couldn't read it overnight. As a result, my lord, I would like to place it on record that this is a trial by ambush, my lord. Yesterday, I had all the day to consult with my client on all the documents that the state is preparing or anticipating to use. However, the documents were not supplied to me, especially the affidavits which were marked by my learned friend, Mr. Baloy, that there are pages that are missing. And my lord, what is very bad in this trial is that the state is dishonest with this court. The state is not telling the truth in this court, that they need time to investigate and to compile all the necessary records that are supposed to be supplied to the defense, so that we can be able to consult properly and then be able to run with this trial. Now, Mr. Host,
I strongly object to the language employed by my learned friend, say that you are dishonest. We are officers of this court, will never be dishonest. No, English is not our language, but I suppose that's not really what, or I want to believe that's not what my learned friend is implying, but we will never be dishonest.
Okay, thank you, my lord. They are honest. The state is honest, my lord. I'm changing from dishonest to honest. The state is honest. My lord, the witness is called now to the witness box to proceed with this trial, whereas we are being supplied with information which is relevant to this witness this morning, my lord, which makes it difficult for us, for even to formulate our defense and the case that we need to put to this witness who is currently in the witness box. My lord, the supply of documents in piecemeal is affecting the whole process, my lord. Today we're giving this, tomorrow we're giving this, and tomorrow we'll be surprised to receive other documents. That's the point that I'm trying to make, my lord. But I'm not saying if the state says they are not dishonest, they are honest.
Is that sarcasm?
My lord, it's because they in front of the court, when my learned friend is making submissions, he's not being truthful to tell the court that we have supplied the documents which were incomplete on the 30th. And we have not been able to finish the defense with the outstanding documents. That's where it's supposed to start. And we still need time, or we're still going to finish the defense with those documents and explain the time as to when we will be able to receive those outstanding documents from the documents that we were finished with on the 30th, on Tuesday, my lord, to start with. Let alone the documents that were sent last night. We have not even given with a reason or whatever, even if we don't deserve the explanation. We received them last night, and this morning we're expected to be ready to proceed with this witness. Those are my submissions, my lord. That's why I was trying to explain the honesty on the part of the state who are working with in this case, my lord. Thank you, my lord.
Thanks.
Mr.
Before you respond,
Oh.
yeah, yes.
May I be permitted to make further submissions, madam?
Yes, I'm listening.
Oh yes, thank you, madam. My lord, I agree with my colleague, Advocate Mshololo. As I've indicated earlier, really, I would submit with due respect. Whatever information that comes after a full disclosure, after the trial has commenced, it's ambush. My lord, it is ambush in the sense that the state is the dominus litis. The defense cannot dictate the nature and the manner of evidence to be presented and the witnesses to be called. But the court, I wish the court to be mindful of the evidence that the state is eliciting at this stage. The state, as the evidence has already been tendered before this court, is trying to refute or rebut the evidence of an alibi. Number two is trying to rebut the evidence that these accused know each other. This evidence that is led in this court by these witnesses relating to the bank statements, relating to the cell phones, it's something that happened after the state brought this or brings this evidence, which occurred after the incident of 2014. I'll say this slowly so that it would be understood to say, during the inception of this trial, even if I was not there, but I followed the records, none of these accused persons tendered a plea explanation in terms of Section 115. No one. The only state, it's a fishing expedition by the state now to say they listened to the version that was put by my colleague Mr. Ramsipidi in one of the witnesses to say accused number one was not in Gauteng on the day Senzo was killed. Now the state wants to focus on that. They now deviate from the elements that they need to prove on what happened in 2014. If the state was confident enough that they have something to say before this court, they should have led evidence. I'm not dictating, but they should have led evidence in relation to, for instance, my lord, let me just put it into practical perspective on what was delivered or was said before this court. Mboto read the affidavit of accused number one. Rapadu read the confession of accused number two. It dealt with the communication where Kelly asked, where are you? Those are records that are relevant. I'm in possession of the 205s for Kelly Kuman. And the state, I'm going to show the state that there was no such a communication. That is direct evidence. I'm not sucking a thumb to say I'm looking for the number for Ntuli, for Mapisa, for whoever. I've got the records for Kelly Kuman on the date of when Senzo was killed. They're busy with 2018, 2021. We are not really interested. That's not our defense. The main defense during Section 106 was that it's a bad denial. They denied having killed Senzo. So now they want to create their own defense because of what my colleague Ramsipidi said. Accused number one was not there. They're busy now. That's why one would be tempted to say they are cooking. They are manufacturing day in, day out.
so that it can fit what the state wants to do. Because I can tell this court now, they don't have a case. I'm not arguing the case, but I don't see the purpose of this witness to be here. Number two, this disclosure, what time do we have to go through? Because if you consult with the client, sentence by sentence, transaction by transaction, is this fair? Is it fair trial to this accused? Moreover, our defense, we blatantly denied, vehemently denied the involvement of this accused in the killing of Senzo Meyiwa. I even put it on my cross-examination or in one of the investigating office. And I still have to prove that that evidence in this court. Now they're busy fitting us with 2018, 2020, 2021. We don't even have time to consult. This is pure ambush.
Okay, thank you.
My Lord, may I say this for the last time? When I get into this trial, it was trial within a trial, the court made it an exception that discovery can be made during a trial within a trial, not in a main trial. Now we're getting everything in. Thank you, my Lord.